Our next speaker is one of the best and one of the guys we enjoy seeing every year, Mr. Nick Debord. Nick is a regional underwriting manager for American Surety and has been specializing in agent recruitment. He's been a licensed bail bondsman in Tennessee since 2008 and has been involved with the bail industry all of his life. His grandfather having been an agent in Kentucky during the 60s. I'd like to welcome Mr. Nick Debord. Always good to see you.
Thank you, sir. I need her back up here a second. Try to figure this out here.
Sir?
I need her back up here a second.
Which one?
The one I was just up here to try to figure out this disc. Yeah. Put this in. Is it under documents?
Maybe. I think hers just popped up. It was just under documents when he put your phone
Okay.
I took mine off. Oh, okay, go to
Documents?
right there, yep. And then go slide on down to that drive right there. Now, right click on it because I don't know why it's opening in that format. I don't know it, but do open with, where's open? I don't know why they're opening in this. Is this it?
Yes.
Click, oh, it should say open with.
You may change the computer?
That's Lauren's
That's not my
computer. Do you have your computer?
So that might,
Yeah,
it
change
probably will do
computers.
better because hers didn't have an updated PowerPoint.
Okay.
And I don't know how got past the
This is
date.
your.
I don't do technology.
You're fine. It's this one. Am I not too tricky to throw that way?
We'll continue on down.
You see that? Okay.
You're up. And then there's your clicker on it. If you're up.
Okay. Okay. How's everybody doing? I'm not going to be as energetic as our previous speaker, so I apologize about that. But my name's Nick Debord. I'm with the American Surety Company. I live up in East Tennessee, but our office is out of Indianapolis. I'm going to be giving you all a brief description on a legislative issue going just on different states across the country. I'll piggyback a little bit on what Michelle said earlier on California and Texas, among some 7 other states, but I'll be talking a lot about Tennessee because this past session, Tennessee got hit really hard and it's a neighboring state. And it's just things to watch out for, and it's going to be good information to know on what's going on in the industry across the country. All right. Okay, there we go. Legislative issues going on across the country. We'll start out in Texas. They modified their constitution to allow for non-serious felonies to be detained without bail, creating a little bit of a preventative detention issue. It's a small move of the needle for them, but it shouldn't have a major effect on bail throughout the state. I just don't like seeing anything done with state constitutional amendments. I think they're there for a reason, and I don't think they should be messed with, but that's kind of what we're seeing going on in different states. Also, there was a charitable bill, piece of legislation introduced. It passed to say that no taxpayer dollars can be used when posting the bill or using that platform, which is good legislation, and it should be replicated in other states. Other big immigration bills, like amending the Constitution to detain all illegals charged with a crime, died. So there's a lot going on, but nothing major. California, I know it's weird that I'm bringing that up because they do things that don't make sense every year. This is the bill that Michelle talked about. Their big fight is over a provision that would refund a premium if the charges are dismissed or not filed within 21 days. It's Senate Bill 562, and the whole reason that this bill got brought up is because the sponsor of the bill had a family friend which was arrested on a domestic charge. Charges were dropped about 3 or 4 days later after the posted bail, and they asked about a refund and they couldn't get it. So that's why this bill got brought up. Part of the industry has went neutral on it, which does not help. The bill is going to the Assembly after having passed the Senate. So another thing, what you're going to find out there is, domestics are a major part of the bail bond business, not just out in California, but everywhere. Domestics, DUIs, but first offense domestics in California are $50,000 bonds across the state. And I don't know where the 21 days come up with. So if you get charged and they don't get indicted, or if the charges get dropped within 21 days, then you're going to have to refund the premium. So the agents are probably going to, just hold on to that money and see what happens after the 21 days. There could have been things done. There could have been kind of a neutral stance if you would have just said, "Hey, I'm signing the bond, but I realize that I'm not getting a refund no matter what happens to the charges." And then everybody could have moved forward with something simple like that. Utah. Agents and the American Bail Coalition worked well together and had good success. Nothing major, but they worked with the State Sheriff's Association and to reinstate the statewide bond schedule that had previously been repealed. Out in Hawaii, you're seeing some other charitable bail bills that were having to get filed, and it was to create the right to bail we can afford system. American Bail Coalition again worked with the agents and they put together a media strategy to sink that piece of legislation. Our next door neighbor, Alabama, this bill was just killed. It's House Bill 42, and if it would have passed, it was filed that would allow a local judge to pick a percent to the court for the bond to be placed. So instead of going through us, they would have just said, go over to the court and make a $1,000 bond, or go to the court and pay them $1,000, and then you just get out. The judge would have had the discretion on all of that. But the Alabama Bail Association worked hard, and they were able to get that bill killed. Louisiana, they passed a really good bill. House Bill 100 passed, regulates the use of electronic surveillance devices by bondsmen, by bail enforcement agents in Louisiana. So now, with the proper warrant and order from the court, agents or companies will now be allowed to place a GPS tracker on vehicles on failure to appear when they do their due diligence. I know that will be helpful because nobody in here has ever, illegally placed a GPS monitor on vehicles when they're looking for people. But I mean, it's a good entity to have, and it's the first state that I've seen pass something like that. South Carolina, they had a big bill about a year and a half ago. It was a bipartisan from both sides of the aisle. They have both professional riders and surety riders, and this had to do with mainly the surety riders within the state. All surety agents have to have their P&C license along with their regular bail license. This requirement knocked out they had a little over 500 agents that were riding through surety companies, but it knocked about half of those out once this bill went into place, either just because they didn't take the test or they failed the test. But that doesn't mean they can't go back and take it, but it did knock several agents out at the time this legislation went into effect. Within the same bill, it allows for a payment plan provision to be accepted. However, if two or more consistent payments are not met, the bondsman will be required to revoke the defendant's bond. So, that can be a good thing from your all's business perspective. Also, if a defendant violates a GPS order, the bondsman will be allowed to forfeit the bond just on, then just go through their regular forfeit process, whichever those laws are in South Carolina. In Indiana, they've been trying to do a Senate joint resolution for the last couple of years to create a broad preventative detention. It did not move this session, but it still can get brought up next year. The state association also tried to get defendant's choice, where it would allow the defendant, not the judge, to decide if they want to post a bail bond or cash, which did not get any traction this past session. The reason that got brought up is Indiana, you can pay 10% to the bondsman, or you can go pay 10% to the court, statewide. So you can do that now, but they were wanting to give that choice directly to the defendant. This Tennessee is going to. We're going to talk about Tennessee for a while, just because of all the craziness that had happened this past year. It was a huge legislative fight, and there was 5 bills that had passed that's greatly going to affect the bail industry. Some in a positive manner, most of which will be in a negative manner. They kind of really got their butt handed to them this past year. The first bill is the 5% bill, and it requires a minimum of 5% premium to be collected on all bonds before being posted. Overall, Tennessee has a higher number of licensed bail agents, and the 1% and 2%ers has created a problem for a while. Tennessee has a population of about 7 million, 95 counties, and they've got about 1,800 licensed bail agents, and then about 400 or so company owners. So the competition is high, and that has created this problem in a sense, and so the courts were kind of fed up with that, and so they had this passed. Still no more than 10% for in-state and no more than 15% for out-of-state defendants. Right now, this will go into effect July 1st. Right now, if you're a surety or a professional agent in Tennessee, there's hardly any requirements through the Department of Insurance and Commerce. You go and you pay your $55 or $60 fee, get your little license through the DOI, and you just reapply that every 2 years, or renew it every 2 years. You don't have to do any other type of licenses. Education through the DOI, the state association, has always been the main providers of the education. So there was a big bill that was brought up this year, and so as it stands today, the courts have full discretion over bondsmen. Approval, suspension, disqualifications, etc., and each criminal court judge can set their own local rules on requirements and regulations. As of January 1, 2026, there will be a bail bond board configured of 7 members, which will basically oversee the industry and report to the courts or the DOI as required. The 7 members will include a judge, a district attorney, a sheriff, a clerk, and 3 bondsmen, who will be selected by the Speaker of the House, the Speaker of the Senate, and the Governor. The board will oversee complaints, approve individual licenses, companies, set rules, etc. So this bill was introduced by a particular state senator who had it out against the bail industry. He didn't come to the association or anyone to try to come up with a good bill together. And we tried to talk to him. This could have been a better bill, and it still can be, just things that need to be incorporated better into it. Because of this bail bond board that's being created, no policies have been made on it. Nobody knows what the consequences are if you violate a law, or if you get arrested, or if you send in complaints. None of that is set in stone yet. So this board is being created. They're going to kind of make up their own policies throughout this first year, and then they got to reconvene and go over they got to take it back in front of the legislature next year to see if they're going to finalize and adopt what they've come up with. A monitoring bill. Effective July 1st this year, all monitoring companies must have an office that is open 24 hours a day, 7 days a week, and have the capability of immediately placing on the device. Does some people here, if you get somebody out that has a court-ordered GPS on a Friday or Saturday or in the middle of the night, will they make them wait there until Monday to get it put on, or they put it on pretty much 24/7? Sit the 24/7? Do people
If they have one available.
If they have one available? So there are many counties across the state of Tennessee that, if you get arrested on a Friday, you're sitting there until Monday to get that monitor on, even if your bail's been posted. They've had major holidays, because the counties will have a contract with one particular monitoring company, and they're not employed by the court, they're not employed by the probation or anything like that. So they're going to work when they want to, and there's nothing that anybody can do about that. So it has caused major issues. So this finally will hold their feet to the fire a little bit, and they're actually going to have to be on call just like you all are. A bondsman can no longer own a monitoring company and a bonding company together, and vice versa. There are companies that do that now, and they will be grandfathered in with this provision. The reason that got put in this bill, there was an incident in Davidson County, Nashville, this past year, where a defendant was bonded out on some pretty serious aggravated domestic charges. Court ordered GPS. Not all the details got relayed from the court to the jail and the bondsman. Everybody, played a little bit of fault there. The defendant was released without the monitor on, got it put on late, but in the meantime, there was an issue where he went and killed the defendant, or the victim, and then had the monitor put back on, and so ended up back in jail, but it was a big ordeal. They had a 6-judge panel hearing on it. The legislature got involved, so it was on TV quite often. So that's why they put this provision in there, just to kind of negate that conflict. A bail tax bill. Right now, and you have to pay a $12 bail tax on every bond that was written, and you have to submit that each quarter to the Tennessee Department of Revenue. And that gets split up a few different ways. A portion of it goes to the AOC, a portion of it goes to the state, and then the association, the bail association, will get a portion of that back for educational purposes. Companies will be required now to submit quarterly reports beginning in October to the Tennessee Department of Revenue stating each bond they wrote and from each county the bonds were written. The clerks of courts will also be the clerk of courts will also be required to submit these bonds written from each county to the Tennessee Department of Revenue. The revenue will be allowed to use these reports for audits to determine the proper tax that's been paid. So right now you have your 10-tap account, and you just go online and say, hey, I've wrote 20 bonds this past quarter, or 150 bonds, and that tallies up, and then you just have that withdrawn from your account. You don't have to submit any proper documentation with that. So not every company's being truthful and how many bonds they're going to be writing. So that's why this got brought up. The clerks are not too happy about this. And neither are the bondsmen. I mean, it's going to be hard you're going to have to use your system that you have with all the bail that you've written, and then get with the clerks and see if you can't make those reports look and be accurate, and then submit your proper amount. So it's just a lot of legwork, a lot of extra paperwork that you're going to have to do. But I would expect this to be modified next year, just simply because the clerks don't want to, they're kind of up in arms about this. The biggest bill that was passed, I say bill, it's a constitutional amendment. I briefly I remember talking about this here last year, that this was out there and it had the ability to be passed. Well, it did get passed, and Tennessee changed the state constitution this past session that will allow the courts to detain defendants on a number of charges pre-trial without any type of release. This bill passed through the legislation in the last 2 years and will go for a popular vote November 26th or 2026 for finalization. In my opinion, it's one of the most unconstitutional procedures I've seen, just because of the amount of charges where a judge will have the ability to hold you without any type of release. They preached on tough on crime, safe streets, reduced crime rate. The bondsmen don't want this only because it's taking money out of their pockets, et cetera, et cetera. That's what the legislature harped on. And Michelle was right earlier, because the sponsor of these bills were all Republicans. They're not one of these bills that I was talking about was supposed to be sponsored by Democrats. So I mean, it's both sides of the aisle that are for and against us. Breaking this constitutional amendment down a little bit more, it expands provision of the offenses that can be held pre-trial without any type of release. Right now, it's capital murder is the only one. But all prisoners shall be bailable by sufficient sureties unless for the following: when the proof is evident or the presumption great. Capital offense, act of terrorism, second-degree murder, aggravated rape of a child, aggravated rape, grave torture. Okay, those charges right there are reasonable, and I think any of us could agree that they would understand why this person is being held without bond. And that's what That's what the association and the bail industry try to get them to amend this, saying, hey, we will accept if you just go with those charges, and not where it says, and any other offense as of November 3rd, 2026, a defendant, if convicted, cannot be released prior to the expiration of at least 85% of the entire sentence imposed. There was a Truth in Sentencing Act passed a couple of years ago, and if a person is charged and sentenced and they have to serve at least 85% before they can be released, that expands that to about 70 charges, or 75 charges. So they're adding that in there. And that's a great deal of the bail that people write in Tennessee, especially in Davidson County, Shelby County, Knox County, Chattanooga, all those metropolitan areas. There's a ton of drug charges. There's all kinds of things that are that get interloped in that. I think it's very unconstitutional. You know, you're basically telling the person they're guilty without even hearing their case, without even taking them to court. It may not have a great effect in the beginning, but over time, your jails are going to get filled up. It's unethical. There's a lot of things that's wrong with that, in my opinion. And I think that wraps up kind of, you know, the state-to-state thing, what I was wanting to talk about. But, you know, Tennessee was a big one. It's next door. And you're seeing a lot of these constitutional amendments now, and creating preventative detention going across the country. With that, I'll end. But I wanted to talk about the American Bail Coalition. They're having their conference. They just went online. You can go on and register for it, and it's not far from here in New Orleans this year in November. There's the website. You can go on and early bird register. It'd be a great conference. It's only a day and a half, a ton of information. And there's my information one more time. Any questions or comments? Yes. All right. Thank you, everyone.